Hi, this is Bezel Bay, and today you'll be enjoying Wtdta Radio, where we'll be exploring the world of accounting, current expected credit loss provisions, estate planning, and tax planning, just to name a few. Don't forget, in the evening session, we'll be definitely going into civics and syntactical trust. So remember, if you listen long enough, you will definitely learn something. Peace and love, family. Peace and love.
NOTE, they send the note over to the title company. And the title company is the one who insures the note. Why I'm saying this, because every single last one of our people out there may not even realize they have what you call is a title policy. There's two types of title policies. One is the homeowner's title policy, and the other one is the lender's title policy. The reason why I'm saying this is because when the mortgage falls into default, as they say, well, you got to begin to start looking at the mortgage and looking at the title policy, because the title policy is the insurance policy to the mortgage contract. Clear? The title policy is the insurance to the mortgage contract. Clear? We got it? So what I'm saying here is that when the mortgage falls into default, there is what you call a mortgage insurance clause. In that mortgage insurance clause, it says that the lender is protected on loan if there's a default or non-payment. That's what the mortgage clause says in that insurance. That's in the mortgage. But it also ties in with the title insurance, because remember, the title insurance is the one who are insuring the title in reference to the note as indebtedness to the mortgage. When you begin to get the title policy, they have what you call is terms and conditions. Is exactly what we was reading up here. Terms and conditions. Why I'm saying that, because in the title policy, the terms and conditions, one of the things that they have in there is what you call is the arbitration clause. That arbitration clause within the title policy of the terms and conditions specifically talks about the American Arbitration Association. Again, it's the American Arbitration Association. Why am I making mention of that? Because within the policy, if there is an adverse claimant against your title, right, you can notify the title insurance company concerning the default, and you can actually set up what you would call an arbitration in reference to that insurance. That is no different if you had a car accident, and when the officer comes on the scene and writes up what took place on the accident for the insurance company, my point is that the insurance company would send out what you would call as an adjuster. He would come out and begin to start to do what? To make an assessment of the damages. The police report on the statements that's being made by the parties is all going to go into what we call an arbitration review. That's a place that you don't really find yourself at. That's the administrative process that we don't really know that we should know and learn of. Once the arbitrator come to the conclusion between the statements of the party and sending out an adjuster for the damages and see how the accident happened, who was at fault for the accident, then they're going to determine the payout. You follow me? Well, it's supposed to be the same thing with the mortgage. When there's a default in the mortgage, you're supposed to contact the title insurance and saying that the mortgage is in default. So technically, what they should be doing is taking a portion of that insurance and paying what's the arrears on. So if you've been in arrears for 3 months, 6 months, 9 months, a year, that mortgage insurance is supposed to cover and pay those arrears. All right? That information, again, is in the title policy and the terms and condition, so you know what's going on. But again, this all can be arbitrated with the American Arbitration Association. All right? They are listed there within the title policy. But people is not going to be aware of this information. Why? Because the title companies and the attorney at the table at the time that you sign the mortgage do not make it known or don't even disclose it to you, or not even being transparent enough to allow you to see or even have your title policy. So now what I'm going to say to you, so you'll be aware of it, if you have what you call as a settlement statement or a closing statement or a HUD-1 statement, when you begin to start reviewing the cost of your loan, you'll begin to start seeing the abstract title or the title insurance, and you have paid for that policy. So you're supposed to walk away from the closing from that with your policy. So when you begin to start reading the terms and conditions of your policy, if something happens in reference to you having a financial hardship and you're missing payments, all right, it specifically spells out what you have to do. You have to notify the title insurance just like you would notify your insurance company if there was an accident with your car. It's the same thing. It's the same difference. Is it clear?
Clear.
You with me with that?
Clear.
All right. It specifically says that these terms are often come in the form of, but are not limited to. See? Forum selection. So what I'm saying, there is a forum selection in your title policy. That forum selection is called the arbitration or the American Arbitration Association. That is actually the clause in the title policy. But I noticed that when I studied the mortgage, you don't even hardly see that at all, the arbitration clauses, which can limit, listen, which can what? Limit or what? Foreclose a party's access to the courts. Do you hear what I'm saying? I don't know if you're picking up where I'm coming from. I'm showing you because of the arbitration clauses that they don't put in your mortgage, but where is the information in your title policy? And what does it do? It can limit or foreclose a party's access to the what? Courts. And also liquidate damages clauses. This is coming from the title insurance. This is exactly where this is coming from. Which set a limit to the amount that can be what? Recovered or require a party to pay a specific what? Amount. So what I'm showing you here tonight, that if you fall 6 months behind, 9 months behind, a year behind, because of that terms and conditions within your title policy, when you notify the title insurance company, right, concerning the fact that your mortgage fell into default, they have to determine how much losses or damage, equitable damages, that the quote-unquote lender from the bank or the mortgage company has sustained. And they would make the determination to set the limit to the amount. But guess what the lender does? He wants to accelerate what? The full amount. He wants to get paid in full. This is what the lender does. So what I'm showing you here, that everyone who has a mortgage should contact the closing attorney who you sat at the table with, or go and look at your HUD-1 statement, which will be your closing statement, which is dealing with your closing costs, or your settlement statement, and it falls under what you call RESPA. RESPA is 26 U.S.C. section 2601 et al., which means, and there are other statutes, all right? And you can request your title insurance policy from the loan servicer. See, people don't know about their title policy, that you can accept, get that from RESPA as a request. And by law, RESPA would have to provide that information. But again, it's 12 U.S.C. Correction, it's 12 U.S.C. 2601 et al., which means there's other sections that you can read in reference to servicing of your loan by the loan servicer. All right, because the loan servicer is the one who's servicing your loan on behalf of your escrow. All right, because he's supposed to be servicing your loan for you based upon your escrow. But I'm giving you specific information to show you here tonight, because this is information that people is not aware of, that your title policy can keep you from going into what? Foreclosure. And that the lender technically cannot accelerate your loan. But what happens is, for them to put down that they can accelerate your loan, that will be considered to be what you call is an adhesion contract, because you sign off on that contract and the lender is prejudicing your right because you don't know anything about the title policy, and the title policy specifically is showing you that you can limit or foreclose on a party's access to the courts, which means you don't have to go to court because they have the arbitration association where you can arbitrate this matter, and they can look at, they can see exactly how much.
Question from Facebook.
Yes.
What if someone already had a foreclosure without this knowledge? Can they go back and sue?
Yes.
From Lovely Me Stanford.
Good question.
Excellent question. You know, when it sits idle too long, of doing every once in a while.
I'll touch it.
Yeah, exactly. So that way it will close down on you.
You need me to repeat the question?
I wouldn't want nobody to know my code.
Want me to repeat?
You already tried to access me already, so you know how that is.
Want me to repeat the question?
I got the question,
Okay.
beloved. Thank you. Appreciate you. Yes, you can sue. You can sue. Because again, under RESPA, which is Real Estate Settlement Procedure Act, you can bring a claim. Matter of fact, I don't know how long ago or how far back you're going with it. 9, 10, and 10, what they do is they close your account out. They close your account out, and I don't know if they destroy the documents. I'm not sure what they do. That's why it's so important to hold on to your material. You know what I'm saying? Because if you don't hold on to your material, the banks is not going to want to try to produce that, or the mortgage company is not going to try to produce that, because they know that you have a defense. All right? So it's very important to secure your documents, even if you have to put it in the safe deposit box, because that's your money. So that's a very good question. Again, that's providing that if you can get the information. Now, when your mortgage has been foreclosed on and it's been 5, 10 years, possibilities that even if you was to try to put that RESPA request to the mortgage company or to the loan servicer, they may have it, they may not have it. All right? They may just close out the whole entire account. All right? But what the recourse that I do see is 2 factors. One factor is you having your own closing documents. That's your recourse. The second recourse is you can still do what you call as a securitization audit. If you do a securitization audit, that will be able to put you in a position to be able to make your claim. A securitization audit. Any other questions from Facebook?
That was the question that popped up.
All right. Any other questions? That's it.
There's a question that says, can this method work for someone who owns a co-op?
Yes. You know, thank you for bringing that up. Man, I'm telling you, the spirits are working as far as the ethos is concerned. A couple of days ago, I was in Brooklyn with Amore's sister, and I got a treat for you. Since you, man, listen, it's just so interesting that people can ask me some questions, and I'm walking in that realm. And in the realm that I'm walking in, people ask me questions in the realm that I'm walking in. So that's showing you how much in tune that I am about what's going on, as I was saying before, about the economic gentrification and the accounting fraud that's going on. This beloved sister sublet or subleased her unit out. And of course, within the bylaws of the Board of Trustees, they don't allow you, or you would have to get permission to be able to sublet your unit out, which you have shares in. She had left to go and live in another state and rented out her unit. And the person or the party who was in her unit was giving her a rough time, so she had to evict them out of there and get back her unit. What the board did was, apparently they were paying attention to what was going on with her case and pulled her public record showing that she had to evict this person out of her unit. So what they did is they put a notice of eviction and attached the judgment in her favor to get that party out of her unit. So now they want to evict her. They want to disenfranchise her from her shares and her equity. All right? But I was telling her, we're not going to wait for them to bring an eviction against you. We're going to bring them to court, because this is what the co-ops are doing that most people don't know about. Right? So I had a couple of co-op cases, and this is the reason why I'm so fluent in that area. What's going on is the co-op board would make decisions without the shareholders, because what they're supposed to do is the shareholders are supposed to agree to the election of what the board wants to do in reference to the maintenance or whatever the situation is with the co-op. But the boards don't do that. They make their own decisions, and what they do is they will take all the leases or the shares of the shareholders of the co-op, right, and they will collateralize it and get a mortgage on it. Do you hear me what I'm saying? They would collateralize all the leases of the shareholders, and then they would get a mortgage on it. They did not get consent from the shareholders of their units for the board to get a mortgage on their units.
What I'm saying is it's the same difference.
Yes.
Of what the shareholder did with her
That's right.
occupant.
That's right.
And
that's right. That's beautiful that you point that out. If I don't know if she's watching, but she would have said, man, you sure you wasn't in her unit? Because that's exactly what I told her. Because when I began to start looking at the bylaws, it makes mention about abandonment under certain articles, and it mentions about subletting, and it talks about assignments. So it falls under assignments. So what they did is they took all the leases and they assigned it in the form of a mortgage to get the mortgage loan. It got so bad